Make sure you're staying up to date on the latest voting rights and election news. Subscribe to Democracy Docket's free newsletters. Click the link in the upper right-hand corner of the screen right now to subscribe. 2023 has seen some serious ups and downs for the Voting Rights Act. Here's what you need to know about the state of the VRA and the threats it faces. This is Defending Democracy, a weekly podcast from Democracy Docket. We're your hosts. I'm Mark Elias.
And I'm Paige Moskowitz. Let's get started. Mark, there's been a lot of recent news around the VRA and how it's been enforced. Given all the litigation that's happening, I think now is a good time to do a status check on the VRA and how it's fared this year.
Yeah, so this has been a really good year for the Voting Rights Act. You know, I think if you go back and Paige, remember where we were a year ago. We were all worried that the Voting Rights Act could be gutted in a case that had just been argued and had not yet been decided, called Allen v. Milligan. This was a case out of the state of Alabama over whether that state needed one or two Black opportunity congressional districts. But when the Supreme Court took that case and it was argued in the fall of 2022, people were really worried. And we kicked off the year with a big win in the U.S. Supreme Court. The Supreme Court reaffirmed the traditional test that had been used for decades to prove Voting Rights Act violations. It upheld the decision of the lower court in Alabama. And Paige, we've already seen that led to the creation of an additional Black opportunity district in Alabama. We are well on our way to having the same results in a very similar case out of Louisiana. We saw a full trial take place in Georgia in 2023 after Allen v. Milligan. That is leading to the same results in Georgia. And then on the state legislative level, we saw in Washington, North Dakota, and Georgia, all states where their part of their legislative maps were thrown out under Section 2 of the Voting Rights Act. Galveston County, Texas, saw its local county districts successfully challenged under the Voting Rights Act. So all in all, you know, we oftentimes, Paige, focus on the bad news. But all in all, it was actually a very good year for Section 2 of the Voting Rights Act, and therefore for voters. And most pundits didn't see that coming.
It was a really good year for Section 2 of the VRA, but there were also setbacks. Most notably, the Eighth Circuit has ruled that there's no private right of action under Section 2. This was kind of a very legally decision. So Mark, what does this mean in reality?
So Paige, let me just start by saying you always find a way. Every time I talk about the good things, you always find the things to worry about. And you're right here. Worrying about the Eighth Circuit decision is real. It has been the case since the enactment of the Voting Rights Act in the 1960s that it has been enforced not just by the Department of Justice bringing claims saying a state or a county has violated Section 2 of the Voting Rights Act. It's also been enforced by having private parties, whether it is civil rights organizations or individual voters, them bringing claims to vindicate Section 2. And in fact, the dissent in the Eighth Circuit noted that out of the 200 successful Section 2 claims brought in the last 40 years, only 15 of them came from the Department of Justice alone. So a lot of enforcement of the Voting Rights Act. The cases we just talked about, Allen v. Milligan in Alabama, the case in Louisiana, the case in Georgia, all of those are cases that were brought by private parties. My law firm, in fact, was involved in bringing all those claims. But most of these claims generally are brought by private parties. And what the Eighth Circuit did was adopt a heretofore never adopted legal theory. Paige, feels like we're constantly talking about never adopted legal theories. Here, they adopted one that said that only the Department of Justice can bring those claims.
Mark, I don't mean to rain on your parade about bringing good VRA news, but the Eighth Circuit decision was big, but maybe not immediately as impactful as people think. Does this decision affect the entire country or just the Eighth Circuit?
Yeah, so that's really important. I hope everybody out there is listening to this and pays careful attention. The Eighth Circuit is one of 13 circuit courts in the United States. You have 11 circuits that are divided, have various states. You have the DC Circuit, which covers just Washington, DC. And then you have something called the Federal Circuit, which hears other kinds of claims, but not voting rights claims. So if you look at the 11 circuits that cover states and some territories, and you include the DC Circuit that covers DC, that's a lot of different locations. And the Eighth Circuit only covers Arkansas, Missouri, Nebraska, Iowa, Minnesota, North Dakota, and South Dakota. Now, that's not to minimize the harm of this Eighth Circuit decision, because if you're living in one of those states, the case that came up to the Eighth Circuit came out of Arkansas. If you're living in Arkansas, it's little solace to say, well, it doesn't apply everywhere. It applies there. But it's important to know that there have been court cases that have actually decided the opposite of the Eighth Circuit. The Fifth Circuit, which is oftentimes viewed as one of the most conservative. This is, Paige, you and I talk a lot about the Fifth Circuit and the cases that come out of there, not just around voting, but about reproductive rights and other things. Very conservative circuit. They recently ruled the other way, and by that I don't mean they sort of ignored the issue. They explicitly held that there is a private right of action under the Voting Rights Act in the Fifth Circuit. So that means in Texas, Louisiana, and Mississippi, there is explicitly a private right of action. Several years ago, going back a while now, the Sixth Circuit did the same. They also held affirmatively that there is a private right of action under Section 2 of the Voting Rights Act, and that is Kentucky, Michigan, Ohio, and Tennessee. The 11th Circuit, which covers Georgia, Florida, and Alabama, they ruled in a case that was ultimately vacated for other reasons, not having to do with the private right of action reasons, but they also held in a decision that there was a private right of action. And of course, Paige, the U.S. Supreme Court has been deciding case after case after case, including most recently the Alabama case, assuming that there was a private right of action, which just goes to show you how fringe the legal theories being advanced by the other side are right now.
Mark, I think most people are wondering what empowers the Eighth Circuit to say that there is no private right of action. Is there something not said in the law? Is this just a decision they made up?
Yeah, so the statute itself, by implication, creates a private right of action, but it doesn't use those words. It doesn't say, private parties can bring litigation. But that has always been its understanding. That has literally been its understanding in these 200 successful VRA cases. And like I said, VRA cases are not few and far between at the U.S. Supreme Court. The U.S. Supreme Court hears a lot of VRA claims, and even the cases that don't go the way I like, they have assumed, or no one has challenged the private right of action. In all of these redistricting cases, no one at the Supreme Court's always assumed there is a private right of action. So this is a very, very extreme position that has been staked out here. And like some of the other ones we've talked about before, like, for example, the independent state legislature theory, that was just a right-wing theory that made its way all the way to the U.S. Supreme Court. One can assume that this Eighth Circuit decision will likely wind up at the Supreme Court. And I predict that even a conservative Supreme Court is not going to say, oops, we got it wrong all those times before. So I think there's going to be I think this Eighth Circuit decision is likely to go to the Supreme Court. I think it's likely to be reversed. But I think that the reality is that's not going to happen fast, right? We know the Supreme Court hears cases, on a set schedule. I suspect that this case won't get to the Supreme Court in time for 2024. So I think where there are private right of actions, which is essentially everywhere other than the Eighth Circuit, there will continue to be through 2024, and hopefully the Supreme Court will knock this Eighth Circuit case down.
Mark, who's promoting this idea that there's no private right of action under the VRA, and why are they doing it?
Well, so it's the usual suspects, right? This is the constellation of right-wing groups, the Federalist Society, the usual suspects that we talk about, plus Republican attorneys general in states and Republican secretaries of state who don't like the fact that there are voting rights laws. They don't like the fact that there is a Voting Rights Act. Shelby County didn't come out of thin air, right? That was a lawsuit brought by a Republican set of Republican lawyers in Shelby County to try to gut or to successfully gut Section 5 of the Voting Rights Act. The Brnovich decision that we oftentimes hear about, which was a Section 2 decision, that wound up in the Supreme Court because the former Republican Attorney General Brnovich of Arizona was trying to get this Section 2 of the Voting Rights Act. He did not succeed entirely, but he succeeded in cutting it back. The Alabama, who is Allen v. Milligan? Allen is the Republican Secretary of State. And, Paige, as we record this, Brad Raffensperger and the Republicans in Georgia are also in court claiming that the Voting Rights Act may be in part unconstitutional. So Republicans have an antipathy towards the Voting Rights Act generally, and one way they can effectively gut it without overturning it is by limiting who can bring cases. And, Democracy Docket's done some remarkable work in the past in quantifying how many cases DOJ brings versus others. I know you're going to put out a full report at the end of the year, and I'm sure this will be in there, but DOJ does not bring that many lawsuits. It's not a knock on DOJ. They don't have the personnel. They don't have the budget. So the role of private lawyers and private advocacy organizations is vital.
So, Mark, it was a pretty good year so far for Section 2 of the VRA. We're now starting to see these challenges from Republicans about private rights of action, about maybe the constitutionality of the provision. So where do we go from here? What's next for the VRA?
Well, look, the first thing we need, and I don't want to pass over this, is Congress needs to revitalize the Voting Rights Act. We talked a lot, and we heard a lot of people in the public space. The president spoke out eloquently. The vice president, congressional leadership in 2022 about the need to pass comprehensive voting rights legislation. The For the People Act, the Freedom to Vote Act. But one of those bills that was always paired with that was the John R. Lewis Voting Rights Advancement Act, which would restore and strengthen the Voting Rights Act. It would clarify a lot of things that Republicans have tried to make unclear. And while the reauthorization of the Voting Rights Act used to be a bipartisan affair, remember, Ronald Reagan, a conservative president, reauthorized it in 1982 and called it the crown jewel of American democracy. George Bush reauthorized it in 2006, where the vote in the Senate was nearly unanimous and the vote in the House only had 33 dissents. And that bill was championed by Walmart and the Business Roundtable.
We'll also point out a lot of the senators who voted to reauthorize under Bush are still in the Senate and now won't reauthorize it. The Republican senators, we should say.
Correct. And so we can't talk about the Voting Rights Act and where we go from here by only focusing on the courts. And I am one to always focus on the courts. But I am saying we have to put pressure on Congress to reauthorize the Voting Rights Act. I know that is something Nancy Pelosi and Senator Schumer had it as their first bills in the Congress when they both had majorities. Senator Schumer made it the first bill that Democrats introduced again this Congress. But when we get through the 2024 election, and hopefully Hakeem Jeffries is the speaker and Senator Schumer is the majority leader and President Biden is reelected, Democrats need to once again take up reauthorizing the Voting Rights Act because it is a critical piece of protecting free and fair elections.
Mark, Congress needs to reauthorize the VRA. There's no doubt about it. Like you said, the courts won't save the VRA. This is Democracy Docket, though. We do focus on the courts. And I've heard that there's this new group of litigation challenging unfair voting practices using lesser known provisions of the Voting Rights Act. So can you tell us what's going on there?
Yeah, so this is really fascinating. It's something my law firm is involved in. And I think it needs to get a lot more attention and more scale. There are other provisions of the Voting Rights Act that frankly have gone into disuse or in some cases were never used at all. And it is worth dusting off all aspects of the law. We need to use every tool available to us, even if it's not one of the headline provisions of a law. If it's on the books, it's a law, we ought to enforce it. So over the last few weeks and months, we have been filing lawsuits using Section 201 and Section 202 of the Voting Rights Act. In Section 201, which prohibits the use of tests or devices to prevent people from being able to vote. One of those tests and devices that is singled out is vouching. So in the Jim Crow South, there was a requirement in some states that in order to register to vote or to be able to vote, you needed to have an existing voter vouch for your good character. Well, this was just a way to prevent Black voters from being able to register. So vouching laws were outlawed under this. So we have brought a lawsuit in Wisconsin that is seeking to strike down that state's witness requirement for absentee voting. Why? Because requiring the witnesses in the way in which they do in Wisconsin is a form of vouching. It is making the person vouch for the voter. And if it's not a voucher, if it isn't vouching, then it fails another part of the law that we've talked about before, which is the materiality provision, right? If it's not vouching, then it's not doing anything. So either way, the witness requirement in Wisconsin, I believe, violates federal law and should be struck down. Two cases we've brought in against Washington State and North Carolina are much more straightforward. The Voting Rights Act, Section 202C, was put in place in the 1970s to protect young voters from being disenfranchised. And it says that you cannot have a durational residency requirement as a precondition for voting in presidential elections, period. A state cannot say you have to live in a state a certain number of days. Now, they can say you have to be a resident, but they can't say you have to have been a resident for a certain number of days. If you become a resident the day before the election and their same day registration, they have to let you register and vote. And that is right now being violated by a number of states. We brought the first two cases, Washington and North Carolina, to make an example. Hopefully, we can get some other states to change their laws in the meantime, but that applies at least to presidential elections and arguably to all federal elections.
Residency requirement, that's different from a voter registration deadline, right? Because
Absolutely.
Some people were confused about that.
Yeah, and states are confused about this. The Supreme Court has said states can have, for administrative convenience, registration requirements. So if a state wants to say, look, we close our registration books 10 days before the election, then that's legal. And the fact that you may be a resident, if you haven't registered, you're out of luck 10 days out. But the reason why I focus on same-day registration is in states that have same-day registration, they are telling their citizens, we don't have an administrative need to close our registration rolls 10 days in advance or 15 days in advance. We're going to keep them open through the day of election day. And if that's the case, you cannot impose this residency requirement.
So, Mark, let's say I move to North Carolina and I move a week before the election. And I know that North Carolina has same-day voter registration, and I moved to North Carolina from Texas. I can't vote in Texas on election day. I don't live there anymore. But North Carolina is saying I haven't been a resident long enough to vote there, even if I can walk into a polling place, have all my documentation, and register to vote.
Right. And this is exactly what this provision was aimed to prevent, which is the disenfranchisement. It was initially focused on young voters because oftentimes they were the ones who were moving. But it is to prevent people from being caught in exactly the catch-22 you just said, which is that they can no longer they can no longer vote at their old location because they've moved. They are no longer a resident there. But they may not be able to register at their new location, which is why I believe that this is required for all federal elections, not just presidential elections. The statute speaks about presidential elections, but I think it will have broader application.
So that's residency requirements. And I know there's one more that was filed in Georgia.
Yeah, so very, very similar. This is now Section 202D of the Voting Rights Act. And this says that the absentee ballot request deadline cannot be more than 7 days before the election day in presidential elections. So again, it's one of these laws that says you cannot set an earlier deadline for requesting an absentee ballot in 7 days for presidential elections. Georgia attempts to do so as a result of SB 202, that big, massive voter suppression law that we've talked about. They moved the deadline forward. And so we're suing Georgia over that. These cases that I just described, these should be non-controversial. Like the laws say what I just said they did. If you're not sure, go to democracydocket.com and you can read summaries, including the laws, and there'll be a link in the show notes for where you can find that.
Mark, like you just said, these provisions are very specific. It's very black and white what the deadlines are, what the rules are. Why have states been allowed to flout them for so long and just ignore federal law about elections?
So they've been able to ignore federal law because, like I said, people haven't paid attention to these provisions of the law. They were, in the case of the the durational residency requirement and the absentee ballot request deadline. I'm not aware of any lawsuit ever having been filed to enforce these provisions ever in the history of the Voting Rights Act. In the case of the witness requirement, it has virtually never been litigated. The Section 201. So these are novel lawsuits in the sense that these were provisions of the law that were put in place. People didn't pay much attention to them. And over time, states just started to flout them, I think largely out of ignorance. Maybe not ignorance on the part of Georgia and with SB 202, but I think largely, to give them benefit of the doubt, is out of ignorance. But the fact is that ignorance is not an excuse. Whether it is Washington State, which is a solidly blue state, or it's North Carolina and Georgia, which are purple states, or Wisconsin, which is slightly blue. All of these have an obligation to follow federal law and to not reduce the rights provided to voters under the Voting Rights Act. Paige, one other point I want to make so that people don't confuse it. These are not race-based rights. These are provisions that apply to everyone. So they were aimed at helping young voters, principally in the case of the Section 202. Section 201 was aimed at helping minority voters, but they apply to everyone. So all of us have a stake in seeing that these laws are followed because everyone could be affected.
Mark, before we go, one last question for you. You said that these are new lawsuits, they've never been litigated before. What does that mean for how these cases play out? Where do you see them going? Do you think they'll be appealed no matter what the decision comes out as? If the law is pretty clear and states are in violation of it, should these lawsuits be easy to win and litigate?
Yeah, these should be quick and easy lawsuits. Now, there are a lot of things that should be quick and easy. I would hope that where you have sensible election officials, they will simply concede that they are wrong and agree to an injunction and either change their law or have a court order remedy. I would certainly hope that's the case in Washington State, where Democrats control the process. I would hope, for all of the rhetoric, Paige, we get about Brad Raffensperger being somehow different in Georgia. He hasn't acted all that different in a lot of litigation. We'll see what he and Republicans in Georgia have to say about the lawsuit there that, again, clearly flouts the law. In North Carolina, I would hope the election board there agrees to resolve this. There's a Republican legislature, so it may be harder, but all of these states could easily solve this by just changing their laws to comply with the plain text of federal law. Otherwise, we'll litigate these cases, we will win, and that'll be the way we will achieve democracy through the docket. Thanks for listening to Defending Democracy. You can find all of the cases and articles we mentioned today linked in the description of this episode. If you enjoyed today's episode, please leave us a review. To find out more and stay up to date on the latest voting rights and election news, visit democracydocket.com and subscribe to our daily and weekly newsletters. Also, if you're looking for a last present for the holiday season, go to democracydocket.com/store, and I'm sure you'll find something great. We'll see you next time. Today's episode was produced by Ali Rothenberg, Gabby Corporal, and Paige Moskowitz. It was edited by Paige Moskowitz. Defending Democracy is a production of Democracy Docket, LLC.